The purpose of this lecture is to talk about nominative uses of trademarks. And so there is a basic insight that I think is common sense, that the right of a trademark holder to their mark should not preclude other individuals from talking about the trademark holder or its goods or services. And so this basic idea is carried forward in a variety of ways in trademark law. But where we have variety is exactly as to why. So some courts say this kind of use is simply not confusing. Others will invoke free speech concerns, competition concerns, some kind of related consideration that says a nominative use is one that trademark law ought not to reach. When we say nominative use, what do we mean? We mean the use of a plaintiff's trademark to describe the plaintiff's goods and services. Now, this may be done even if the ultimate goal is to describe your own goods or services. Take the Pepsi challenge. We think you'll like Pepsi more than Coke.
This is the taste. This is the test. Pepsi versus Coke. The Pepsi Challenge. Pepsi. And all across America, more people pick Pepsi. Time after time after time.
Pepsi Cola.
Oh, what a time. It's gonna be Pepsi now. The winning taste is Pepsi. It's gonna be Pepsi.
That's a nominative reference to Coca-Cola, but it is done to describe Pepsi as being the better tasting soda. And so this is distinct from classic fair use. In a classic fair use, the trademarked term is used not to refer to the trademark holder or in a trademark sense, but is used to descriptively describe one's own goods. So how do we doctrinally recognize the idea that nominative uses ought to be permissible? One possibility is to treat nominative use as a substitute to the infringement test, and that's what the nominative fair use test of the Ninth Circuit does. Another possibility is to treat nominative fair use as a defense. That is the approach of the Third Circuit. Another possibility is to adjust factors in the multi-factor test to account for the nominative situation, and other courts will just simply acknowledge that this is the kind of use that is at issue without having any kind of discrete doctrinal framework to address that fact. Sort of a rough and ready acceptance of the idea that the defendant should have some leeway to use the plaintiff's mark to refer to the plaintiff. So the most famous discrete test to account for nominative uses comes from the Ninth Circuit. And so there are basically three ideas. And this is that, number one, the product or services referred to are not readily identifiable without the plaintiff's mark. Number two, one only uses so much of the mark as is reasonably necessary to identify the plaintiff's product. And number three, nothing is done with the mark that suggests sponsorship or endorsement on the part of the trademark holder. And so number three really is the big part of the game. And it kind of really gets at that fundamental question of whether or not you are doing something that is designed to deceive the consuming public as to your relationship with the plaintiff. And so this gets the idea that when we're talking about nominative uses, we're often talking about them in the context of affiliation or sponsorship situations, and not so much traditional classic likelihood of source confusion at the point of sale. Now, is nominative fair use a defense? And in the Ninth Circuit, it is not. It is treated as an alternative means of measuring whether or not there is a likelihood of confusion. So there is a recognition that says a nominative use situation raises issues that are distinct from those that we normally cover using the multi-factor test. And so if we want to determine whether or not there is a likelihood of confusion, this particular test is better suited to undertake that inquiry than we would be if we were to simply use the ordinary multi-factor test or in some way modify the multi-factor test to account for the nominative use situation. And so that's the approach of the Ninth Circuit. Now, sometimes it's referred to as a defense, but the idea is that it describes situations in which courts in the Ninth Circuit have concluded that confusion is simply unlikely given the circumstances of the use as measured by its particular test. As the court said in the New Kids case, such a use is fair because it does not imply sponsorship or endorsement by the trademark holder. For example, the classic comparative advertising situation. Try Pepsi, it's better than Coke. No one would think that that kind of ad is done with a sponsorship or endorsement of Coca-Cola. We could imagine, extended theories of trademark rights that say, well, you don't get to do that unless you have Coca-Cola's permission. But then we're the circularity issue, and the Ninth Circuit's test says, no, you can do that, and therefore that kind of defeats the circularity problem, right? Because it is permissible, consumers may not expect permission to be required. Sort of like the inverse solution to the circularity problem we talked about in the context of merchandising. Now, it's important to keep in mind that in courts that take this approach, the burden of proof remains on the plaintiff. So even though the test is phrased in a way that may sound like it's something that the defendant has to come forward and establish, if it's acting as a substitute to the multi-factor test, the burden should remain on the plaintiff, notwithstanding the fact that people often refer to the nominative use test in the Ninth Circuit as a defense. And so the defense phraseology can sometimes lead courts to be a little bit careless. And of course, some circuits, or at least the Third Circuit, treats nominative fair use as a defense, and therefore one in which the burden is on the defendant once the plaintiff has made a prima facie showing that there is a likelihood of consumer confusion. And so a big part of the Toyota versus Tabari case is a correction of the perception that there is some kind of burden on the part of the defendant in a nominative use case. And after KP Permanent sort of clarifies the importance of placing the burden of proof on the plaintiff in a trademark case, that leads to the conclusion, of course, that in a nominative use case, that if that is the framework of analysis, the burden properly rests on the shoulders of the plaintiff to show that the defendant is doing something that suggests endorsement or sponsorship by the plaintiff, by the trademark holder. And so what's going on in the Toyota versus Tabari case? Here we have the Ninth Circuit vacating an injunction against car brokers who are using the mark Lexus in their domain names. And the court, interestingly, kind of notes that brokers may actually be salutary to the consuming public, right? They promote competition and they may lower consumer search costs for those consumers who are looking specifically for a certain make of car. And so, as I alluded to already, one of the important functions of this case was to clarify the burden in a nominative fair use situation, that where the use is nominative, the plaintiff bears the burden of showing that the defendant does not meet the test, and therefore that the defendant is doing something that creates a likelihood of consumer confusion. But the other interesting thing about Tabari is how robust its protection of nominative uses is. The court basically says the district court must allow some uses of the Lexus mark in domain names and make certain empirical assumptions about the appropriateness of doing so. The court also says the defendants have shown an adequate need to those marks, notwithstanding the fact that they engaged in some excessive prior use of the Lexus logos, but that does not defeat their right prospectively to make certain uses of Lexus marks in their domain names. And so how does the court apply the test here? Number one, the product or services are not readily identifiable without the mark. The Tabaris needed to communicate their specialty in Lexus cars specifically, and it is appropriate to make that kind of use even in a domain name context. And so again, you see a certain evolution in the case law compared to what we saw in the relatively early days of the commercial internet, where courts were extremely suspicious of any kind of third-party use of a trademark in a domain name. Number two, is only so much of the mark used as is reasonably necessary to identify the plaintiff's mark? And the answer here, again, is yes. There was some excessive use in the past, the use of the logos on the actual page, but the defendants have scaled that back. And this kind of goes to the third prong as to whether or not anything is done with the mark that suggests sponsorship or endorsement. And the court says, under the circumstances, it is possible to make these kinds of uses in the domain name without suggesting sponsorship or endorsement. And one of the many interesting things about the Tabari case is how open to third-party uses of a trademark the court is. And it's a very different tone than a lot of cases that we've seen in the past, and even from the Ninth Circuit, thinking about a case like Brookfield. And indeed, this invites a concurrence that objects to the conclusions on the part of the majority that internet consumers are sophisticated and unlikely to be misled, right? These are very different consumers in the court's eyes than what we saw back in the days of Brookfield. Here's this idea that consumers are sophisticated. They know that just typing in blindly at trademark.com is not going to necessarily lead them to their site. They should know that they have the access to search engines. They should be accustomed to the idea that some domain names may have a trademark term, but absent a situation of trademark.com, it is not reasonable to expect that any mention of a trademark automatically will take you to a site affiliated with the trademark holder. And the concurrence says this is fact-finding, right? And this should echo the objections of the dissent that we talked about in the earlier case involving MTM and Amazon watches. This idea that the appellate court should not be determining how sophisticated consumers are, that's properly a fact question. Now, of course, given that likelihood of confusion is directed to the reasonable consumer, there is an inherently normative component to that kind of analysis, particularly since, as we've talked about before, someone somewhere believes just about any proposition you can imagine. So where you set the expectation is something that a court necessarily has to do, unless trademark law is going to reach everything, insofar as someone somewhere is always confused about any proposition that you can possibly name. The concurrence also objects to the idea that, the relevant consumers are accustomed to being online, or that consumers are agnostic as to the source of sites suggested by search engines until they arrive. And so again, the majority kind of assumes that you're not going to be misled by a trademark and a domain name unless it's really the extreme case of trademark.com, Lexus.com. But the Tabaris aren't using Lexus.com. They're using buy or lease a Lexus.com. And that kind of thing is not problematic in the eyes of the majority. The concurrence objects. The concurrence also objects to the idea, or to the assumption, that the defendant's conduct is meritorious, that it actually benefits consumers. Again, thinking about this as being a form of fact-finding that isn't justified by the record below. So again, I really think one of the big deals about the Tabari case is the majority's conception of consumers. Just sort of saying unreasonable, imprudent, and inexperienced web shoppers are not relevant. It's not that someone somewhere couldn't possibly be confused by the Tabari's behavior. It's just that the court thinks that kind of confusion is not reasonable. It's not keeping in the standard of care that a reasonable consumer ought to exercise in order to expect the protections of trademark law. The relevant consumers know how to shop online. This isn't the beginning of the internet era. We are now several decades into it. And so, we can quibble about this, or there's a lot to muse about here. I think given the inherently normative task of calibrating the consumer for purposes of likelihood of confusion analysis, I'm not so put off by the claim that this is overt appellate fact-finding. I think this is something that courts have to do and do in any number of likelihood of confusion situations. And the reason this is noticeable is that the court is taking a normatively more pro-defendant construction of the consumer. But in other cases that are more, purport to be more agnostic about what the consumer level of care actually is, are actually making a normative judgment of their own. The idea that trademark holders should have maximal protection from the courts, and that any level of consumer confusion, or a relatively low level of consumer confusion, or consumer confusion exhibited by a relatively non-careful consumer, is relevant. That is as much a normative judgment as the one that the majority is making in the Tabari case. And so this idea that we can have these shortcuts in fact-finding, we've talked about them throughout the term, and they can cut both ways. And in the Tabari case, we have it cutting very decidedly in favor of the interests of the defendants.